The first thing that felt wrong wasn't what was said in the courtroom. It was the pause before it. That moment of stillness when everyone realizes something has shifted, but no one is quite ready to admit it yet. The kind of silence that doesn't belong in a British courtroom, especially not one inside the High Court. Especially not when the man standing there is a prince. Here's the contradiction that matters right now. Prince Harry came to court demanding accountability, transparency, justice. And yet, by the time proceedings began, it was already becoming clear that he was the one being quietly boxed in. But before we continue, please don't forget to like, subscribe, and turn on the notification bell for updates. Not by the tabloids, not by the press benches, but by the very system he believed would vindicate him. This wasn't a ceremonial appearance. It wasn't symbolic. It wasn't a victory lap dressed up as legal principle. This was a live, active confrontation between a man who believes the media destroyed his life and a judicial process that does not bend to personal conviction. And that tension, that collision, is why this story matters now, not years ago, not when the lawsuits were first filed, not when headlines first screamed about phone hacking and privacy violations. This week was different. Because this week, the court stopped indulging narrative and started enforcing control. Harry arrived in London as a litigant, not a royal. That distinction matters more than it sounds. In the High Court, lineage buys you nothing. Emotion buys you less. The judge doesn't care who your mother was. The rules are the rules, the questions are narrow, and patience is finite. And patience, as it turned out, was already wearing thin. The case itself is serious. Harry accuses Associated Newspapers, the publisher behind the Daily Mail and the Mail on Sunday, of illegally gathering private information. He claims journalists crossed legal and ethical lines, that private conversations were accessed, that surveillance tactics were deployed in ways that should never have been allowed. Associated Newspapers has vigorously denied all of it. That denial isn't just procedural. It's strategic. Because in a courtroom, denial isn't silence. It's a challenge. It forces proof. It forces precision. And it shifts the burden away from emotion and onto evidence. And that's where the tension begins to hum. Harry didn't walk into court this week as a neutral observer. He walked in carrying years of resentment, grief, anger, and a sense, justified or not, that he has been wronged in ways the public will never fully understand. That emotional weight is real. You can see it in the way he enters a room, in the way he sits, in the way he waits. But here's the uncomfortable truth the courtroom doesn't care about. Emotional truth and legal truth are not the same thing. And sometimes, the harder you push one, the more the other slips away. The atmosphere inside the court on Monday was tense in a way that doesn't translate well to headlines. No shouting, no theatrics, just quiet corrections, subtle interruptions, the kind that signal authority without raising volume. The judge didn't need to assert dominance. It was already there, built into the walls, the protocols, the very architecture of the room. Harry appeared confident at first, engaged, willing to speak, perhaps too willing. That's not unusual for someone who believes deeply in their cause. But belief, especially when voiced too freely, can become a liability. Because every word spoken in court isn't just communication, it's material. It can be weighed. It can be challenged. It can be turned. And it can expose fractures. This is where the story quietly changes direction. Not with a bang, with a subtle recalibration. At certain moments, Harry seemed to push beyond what his legal team had prepared. Not recklessly, but instinctively. As if the line between personal testimony and legal strategy had blurred. And when that happens, lawyers don't interrupt loudly. They don't correct in public. They exchange looks. They shift posture. They take notes faster than usual. Those small signals are easy to miss, unless you know what you're watching for. Because when a legal team starts adjusting on the fly, it's often because the script is no longer being followed. Ask yourself this. What happens when a client believes their truth is more important than legal discipline? That question isn't theoretical. It's playing out in real time. By Tuesday, the tone had shifted again. Harry returned to court, and so did the weight of expectation. Not from the press, from the bench. There's a difference between a judge allowing space for a witness to speak and a judge beginning to draw lines around that space. And those lines, once drawn, don't move. The judge's demeanor wasn't hostile. That's important. It was controlled, measured. But there was something else layered into it now, a firmness that hadn't been there before, a sense that the court was no longer simply listening, but actively managing. That management is where things start to feel uncomfortable. Because when a judge starts intervening more frequently, it's rarely about impatience alone. It's about risk, about clarity, about preventing proceedings from drifting into territory that could undermine fairness or credibility. And credibility is everything in a case like this. Harry's argument rests on the idea that illegal methods were used against him, that boundaries were crossed, that the press treated him not as a person, but as a target. Those claims demand careful articulation. They demand restraint. They demand consistency. What they do not tolerate is emotional escalation. Yet escalation is exactly what seemed to be building, not in volume, in intensity. There were moments, brief, telling moments, where Harry appeared visibly frustrated, where answers became longer than necessary, where explanations edged toward narrative rather than fact. Again, not dramatic, not explosive, but cumulative. And courts notice cumulative behavior. So do judges. Behind him, his legal team was navigating a narrowing corridor. Every answer creates consequences. Every clarification opens new doors. And when a client insists on walking through doors that strategy would prefer to keep closed, something has to give. This is where rumors begin. Whispers. Speculation about tension behind the scenes. About disagreements over approach. About how much control a client should have once proceedings are underway. Most of that never becomes public. Until it does. Because this week, something did leak. Not to the press, but through behavior. Through absence. Through subtle shifts that seasoned court watchers immediately recognized as warning signs. At one point, the judge issued what can only be described as a firm caution. Not a rebuke. Not yet. But a line in the sand. A reminder of boundaries. Of relevance. Of the court's authority to decide what matters and what does not. It wasn't shouted. It didn't need to be. The room heard it anyway. And Harry heard it too. That moment matters because it marks a transition. From participation to constraint. From expression to discipline. From a sense of agency to a reminder of limits. And here's the part that complicates everything. Harry has spent years fighting institutions he believes failed him. The press. The palace. The system. Now he stands inside one of the oldest institutions in Britain, being told, politely, firmly, that his fight will proceed on terms not of his choosing. That psychological tension is enormous. You can't fully understand what comes next without sitting with that for a moment. Imagine believing, with every fiber of your being, that you are finally being heard, and then realizing that being heard does not mean being validated. That the court is listening, yes, but listening clinically. Dispassionately, with a different objective entirely. Justice, in this space, is not about emotional resolution. It's about legal sufficiency. And sufficiency is unforgiving. This is why the legal team's role becomes so critical. They are the translators between belief and proof, between grievance and admissibility. When that translation breaks down, even slightly, risk multiplies. By midweek, that risk was no longer hypothetical. Questions began circulating quietly. Why were certain lawyers less visible? Why were consultations longer? Why did Harry appear increasingly isolated at the table? None of these questions have official answers. Yet. But in courtrooms, absence speaks almost as loudly as words. The press, ironically, was restrained. This wasn't a spectacle. It was procedural, and that made it more dangerous. Because procedural moments don't generate immediate outrage. They generate records, transcripts, judicial impressions that linger long after headlines fade. And judicial impressions matter. By the time Harry is expected to return to the witness box again, the dynamics will not reset. Courts don't forget. They adjust. They narrow. They prepare. So the real question now isn't whether Harry believes he is right. The question is whether belief, in this setting, is becoming an obstacle, and whether the court is already preparing for a next phase. One that Harry may not fully control. Because when a judge issues a warning, it's never about the moment itself. It's about what comes after. The room itself tells you how to behave before anyone speaks. That's the first thing people underestimate about the High Court. It doesn't need to announce authority. It radiates it. The ceilings are high, but not grand in a theatrical way. The walls don't impress you. They contain you. The layout isn't designed for drama. It's designed for order. And order, in this space, is non-negotiable. This is where expectations quietly collide with reality. Because when people imagine a high-profile case involving Prince Harry, they imagine noise, flashbulbs, headlines, some kind of emotional spectacle. What they don't imagine is the disciplined stillness that greets you the moment proceedings begin. No murmurs, no reactions, just the low rustle of papers, the soft clearing of throats, and the unmistakable sense that this room has seen far more powerful men than the ones sitting at the claimant's table. And it has reduced all of them to witnesses. There is a rhythm to a courtroom like this, and it is unforgiving to anyone who doesn't learn it quickly. Questions are narrow. Answers are expected to be narrower. Digression isn't curiosity, it's deviation. And deviation, over time, becomes disruption. On Monday morning, Harry walked into that rhythm carrying something heavier than legal documents. He carried years of public grievance, deeply personal loss, and a belief, again, justified or not, that this case represented something bigger than itself. A reckoning, a line in the sand, a moment where institutions would finally be forced to answer for what they had done to him. But the courtroom didn't care about symbolism. It cared about relevance. From the outset, the atmosphere felt off. Not hostile, not chaotic, just slightly misaligned, as if two different expectations were occupying the same space. Harry appeared alert, engaged, ready. The court appeared prepared, reserved, procedural. Those two energies don't naturally blend. One seeks expression, the other enforces containment. That tension doesn't explode. It accumulates. The judge entered without ceremony. No dramatic pause. No acknowledgement of status. Everyone rose. Everyone sat. And just like that, the machinery began moving. It always does. The court does not wait for anyone to catch up emotionally. What struck seasoned observers almost immediately was how quickly the judge began steering. Not correcting, steering. Subtle redirections. Clarifying questions. Small interjections that gently but unmistakably shaped the flow of testimony. These weren't warnings. They were calibrations. Yet even calibrations can feel jarring when you expect space and instead encounter boundaries. Harry spoke with confidence. That much was clear. He answered fully, sometimes too fully. He framed events in context, layered with background, emotion, memory. Again, not theatrically, not recklessly, but persistently, as if completeness were a form of protection. Here's the uncomfortable truth. In court, completeness can be dangerous, because every additional detail is another thread someone can pull. The court's role is not to understand how Harry feels about the press. It is to determine whether specific actions by specific parties crossed specific legal thresholds. That requires narrowing, not expanding. And when a witness instinctively expands, the system responds by compressing. This is where the discomfort begins to show. At first, it manifests in pauses, the kind that feel longer than they are. A question asked, an answer given, then a silence. Not awkward, deliberate. The judge letting the answer sit, weighing not just what was said, but how it was said, what it introduced, what it implied. Behind Harry, his legal team sat composed, professional, attentive. But if you watched closely, you could see the micro-adjustments. Notes passed, pens moving quickly, heads tilting slightly, then stilling again. Lawyers don't interrupt unless they must. They adapt until adaptation no longer works. In this case, very early on, began demanding adaptation. The claims themselves are serious. Allegations of illegal information gathering by Associated Newspapers aren't minor procedural complaints. They strike at the heart of journalistic ethics and legality. If proven, they would matter far beyond this courtroom. That's precisely why the court is so careful. Careful means controlled. It means the court cannot allow testimony to drift into generalized condemnation of the media, however emotionally resonant that may be. It means each claim must be tethered to evidence. Dates, methods, documents, witnesses. Memory alone is insufficient. And memory, as Harry speaks, is everywhere. There is a human impulse at play here, one that almost anyone would recognize. When you believe you've been wronged repeatedly, you don't want to talk about one incident. You want to talk about the pattern, the accumulation, the feeling that it never stopped, that everything connects. The law, however, is allergic to patterns without proof. This is where the courtroom atmosphere tightens. By mid-session, the judge's interventions became slightly more frequent. Still calm, still respectful, but firmer. A rephrase question here, a gentle reminder there, a request to stay focused. Each one small. Together, they formed a message. The message was this: this is not a forum for narrative reclamation. And that matters because Harry's public life has been defined, in many ways, by the battle to reclaim narrative. From interviews to documentaries to memoirs, the through line has been voice. Being heard, correcting the record, finally telling his side. The courtroom is the one place where that instinct works against you. You could see the moment when that realization began to surface. Not as panic, as frustration, a tightening of posture, a slight shift in tone, answers that became more deliberate, but also more pointed. As if he were trying to thread a needle while holding on to conviction. This is exhausting work. For the witness, for the lawyers, for the judge. And exhaustion, in court, is not neutral. It changes behavior. It shortens patience. It increases risk. The public benches remained quiet. No reactions. No gasps. But make no mistake, this was being watched closely. Not just by journalists, but by legal professionals who understand how rare it is for a case like this to hinge not on documents, but on demeanor. Because demeanor is not supposed to matter. But it does. By the afternoon, the atmosphere had shifted again. The court felt narrower, more compressed. The procedural guardrails were visible now. This wasn't escalation, it was containment. At one point, the judge paused proceedings briefly. Nothing dramatic. No announcement. Just a momentary halt. But in court, pauses are never empty. They are decisions being made quietly. When proceedings resumed, the tone had hardened, not emotionally, but structurally. Questions became more direct. Answers were guided more assertively. The court was reclaiming tempo. And tempo is power. Harry remained engaged. He didn't retreat. He didn't shut down. If anything, his focus sharpened. But there was now a visible friction between his desire to explain and the court's insistence on precision. That friction is where cases can unravel. Not because someone loses their temper, but because the margin for error disappears. By the end of the day, no one could credibly claim this was going smoothly. Not disastrously, but not smoothly. The sense of inevitability had crept in. The understanding that this case would not unfold on Harry's terms, no matter how strongly he felt. And feelings, by this point, were no longer peripheral. This is where the irony sharpens. Harry has long argued that institutions silence individuals. That power structures close ranks. That truth gets buried under protocol. Now he stands inside an institution where protocol is the mechanism of truth and finds himself constrained by it. Ask yourself something uncomfortable. What happens when someone who has built their identity around speaking out is told, repeatedly, to speak less? That psychological tension doesn't resolve itself neatly. It builds. As the court adjourned, there was no visible relief. No sense of progress. Just recalibration. Lawyers clustered briefly. Papers were gathered. The judge exited as quietly as he entered. Outside, the cameras waited. Inside, the real damage, or preparation, was already underway. Because this was only the first day. And already, the court had begun drawing boundaries that would shape everything to come. What most people didn't realize yet was that these boundaries weren't just about testimony. They were about tolerance. And by the time Harry returned to the courtroom, the space for deviation would be smaller than ever. But the most consequential shift wasn't visible to the public at all. It was happening behind him, at the table that was supposed to protect him. And once that protection begins to thin, the courtroom stops feeling neutral very quickly. There's a moment in every high-stakes case where the balance subtly tilts. It's not announced. No one stands up and says it out loud. But the people who work in courtrooms for a living can feel it immediately. It usually happens when the lawyers stop looking at the judge and start watching their own client. That moment arrived quietly here. On the surface, nothing dramatic had occurred. No objections shouted down. No testimony struck from the record. No public reprimand splashed across the evening news. And yet, as the second phase of proceedings unfolded, the dynamic had changed in a way that was difficult to reverse. Because this was no longer just a case about alleged wrongdoing by a publisher. It was becoming a case about control. And control, in a courtroom, is rarely where clients win. At this stage, it's important to understand something most viewers never see. A legal team doesn't exist simply to argue law. Their deeper function is risk management. They anticipate where answers might go. They steer. They soften. They limit exposure. When a client aligns perfectly with that strategy, proceedings can feel smooth, even when the subject matter is explosive. When a client doesn't, the legal team shifts from offense to containment. Containment is not a good sign. By the time proceedings resumed, that shift was already underway. Harry returned composed, focused, determined. There was no outward sign of retreat. If anything, there was resolve, the kind that comes from believing you are standing on principle. But principle, in this environment, can be an unstable footing. Courts don't reward conviction. They reward coherence. And coherence was becoming harder to maintain. One of the earliest indicators came in the form of clarification requests. Again, not confrontational, almost conversational, but frequent enough to signal that the court was working harder than it should have to keep testimony on track. Each clarification introduced a pause. Each pause introduced an opportunity for misalignment. Those pauses matter, because during them, lawyers reassess in real time. Is this answer helping or hurting? Is this line opening doors we don't want opened? Is the judge becoming impatient? Or worse, skeptical? The most dangerous moment for any legal team is when they can't answer those questions confidently. Harry, for his part, appeared increasingly intent on context, on explaining not just what happened, but why it mattered to him. That instinct is human, understandable, almost inevitable given his history with the press. But in a legal setting, context can quickly blur into narrative, and narrative invites scrutiny. Scrutiny invites risk. There's another contradiction at work here, one that doesn't get discussed enough. Harry is not a naive witness. He's media savvy. He understands how words land. He understands framing. That awareness, ironically, can make courtroom testimony more difficult, not less. Because the witness who understands optics often struggles to relinquish them. Several answers began with precision and ended with implication. Again, not inflammatory, but layered, suggestive. As if each response were carrying two messages, one for the court and one for a broader, invisible audience beyond the walls. Courts are acutely sensitive to that. They don't object because they're offended. They object because dual audiences undermine clarity. And clarity is everything. This is where the legal team's body language becomes instructive. They sat straighter. They leaned in. At times, they appeared almost frozen. A telltale sign of lawyers hoping a witness will stop talking on their own rather than forcing an interruption that could draw attention. That hesitation is strategic. Interrupting your own client publicly is a last resort. It signals loss of control. It tells the court something is wrong. No lawyer wants to send that signal unless absolutely necessary. But the risk of not sending it can be worse. As testimony continued, a pattern emerged. Answers that technically addressed the question, but also introduced new themes, new grievances, new emotional beats, each one plausible on its own. Collectively, they began to form a mosaic that was harder to defend, because mosaics are subjective, and subjectivity is poison in litigation. At one point, the judge asked a question that should have been simple. The answer, however, was not. It unfolded slowly, carefully, thoughtfully, too thoughtfully. The judge listened without interruption, which, paradoxically, is often more ominous than being cut off. When the answer concluded, there was a pause, then a follow-up, shorter, narrower, almost surgical. It was the kind of question that trims away everything but the core. Harry answered it, correctly, but the contrast between the two responses was stark. One expansive, one contained. The court didn't comment. It didn't need to. The message was embedded in the structure. This is the line. Stay here. From that moment on, the legal team's role became more visible, not through words, but through constraint. They began shaping the space Harry was allowed to occupy, advising during brief breaks, emphasizing brevity, stressing relevance. That kind of guidance is normal. The problem arises when it clashes with a client's internal momentum. Momentum is powerful. Once a witness feels they are finally articulating their truth, pulling back can feel like erasure, like compromise, like letting something slip away again. That emotional resistance is subtle but potent, and it creates friction. Friction doesn't always lead to explosion. Often, it leads to withdrawal, to distance, to quiet disagreement that never quite resolves. This is where speculation about the legal team begins, and where caution is essential. There's no public confirmation of arguments behind closed doors, no recorded disputes. But there are signals, and courtrooms are built to amplify signals. A lawyer conferring more often than expected, another remaining unusually silent. The absence of a familiar face at the table. None of these prove conflict, but together, they suggest strain. Strain matters because it narrows options. When a legal team is unified, they can pivot quickly, adjust strategy, absorb shocks. When unity weakens, every decision becomes heavier, riskier, slower, and the court does not wait for teams to find themselves. By this point, Harry's position had subtly shifted. He was no longer just the plaintiff seeking redress. He was becoming a variable the court needed to manage. That's not an accusation. It's a procedural reality. Courts prefer predictability. Unpredictability triggers oversight. And oversight, once initiated, rarely recedes. The judge's tone remained professional, calm, but increasingly directive. Fewer open-ended allowances, more framing, more structure imposed from above. The message was unmistakable. The court was tightening its grip on proceedings. For Harry, that tightening may have felt familiar. Another institution asserting boundaries. Another system insisting on rules that don't always feel fair. That emotional echo matters, even if the court cannot acknowledge it. Because unresolved echoes shape behavior. As the day wore on, the psychological weight became visible. Not as anger, as intensity. Focus sharpened to a point that risked narrowing perspective. Answers became more deliberate and occasionally more brittle. Brittleness is dangerous. It's the stage where a witness is still compliant, still articulate, but less flexible, less able to absorb redirection without internal resistance. Lawyers feel that shift immediately. This is when internal conversations turn urgent, when phrases like damage control enter the room, when the objective quietly changes from advancing the case to preventing harm. And here's the most uncomfortable truth of all. Sometimes, the best legal strategy is silence. But silence is the one thing Harry has spent years refusing to accept. By the time proceedings paused again, it was clear that something had to give. Either Harry would recalibrate, or the court would do it for him. And courts, historically, are very good at recalibration. What hadn't yet surfaced publicly was the consequence of that pressure behind the scenes. The discussions that don't make transcripts. The ethical lines lawyers must consider when a client's approach threatens the integrity of their own role. Because lawyers don't just represent clients. They represent the process. And when those obligations collide, the fallout is rarely graceful. Before anyone can decide whether a case is righteous, the court has to decide whether it's precise. That distinction is uncomfortable, especially in cases like this, where the moral argument feels intuitive long before the legal one is proven. It's easy to nod along when someone says they were targeted, harassed, intruded upon. It's much harder to translate that feeling into something a judge can rule on without hesitation. This is where the allegations themselves move from background noise to the center of gravity. On paper, the claims brought by Prince Harry against Associated Newspapers are stark. Illegal gathering of private information. Methods that allegedly crossed legal boundaries. Conduct that, if substantiated, would represent not just ethical failure, but unlawful behavior by a major media organization. Those words sound heavy. They should. But courts don't weigh words. They weigh mechanisms. How was the information obtained? When? By whom? Using what tools? And, most critically, how can you prove it? This is where cases like this often falter. Not because the harm isn't real, but because the path between harm and proof is narrow, technical, and unforgiving. Associated Newspapers has denied the allegations vigorously. That phrase gets used casually in coverage. But in legal terms, it has a specific function. A vigorous denial isn't about tone. It's about forcing the claimant to climb every rung of the evidentiary ladder. No assumptions. No inference leaps. No, it must have happened because it feels true. The court doesn't operate on probability. It operates on demonstration. And demonstration requires restraint. Harry's case spans years of alleged intrusion. Years of headlines. Years of stories that felt, to him, too precise to be coincidence, too personal to be chance. That cumulative experience fuels conviction. But conviction, again, is not admissible evidence. Here's the contradiction that sits at the heart of this chapter. The stronger Harry's certainty becomes, the more carefully the court must slow him down. Because certainty invites generalization. And generalization is where legal cases go to die. The court needs specifics, singular incidents, concrete actions. The legal threshold isn't this felt invasive. It's this specific action violated this specific law. Anything outside that frame becomes noise, emotionally compelling noise, but noise nonetheless. As Harry articulated his claims, that tension surfaced repeatedly. His answers weren't incoherent. They weren't evasive. But they often tried to do more than the question asked. To explain the ecosystem, the culture, the sense of being hunted rather than reported on. That instinct makes sense to a human audience. It resonates. It draws sympathy. The law, however, here's a different message. You are moving beyond the charge. This is where the court's patience intersects with its skepticism. Judges are trained to separate sincerity from sufficiency. They can acknowledge that someone believes they were wronged without conceding that the legal standard has been met. In fact, they must do exactly that to preserve fairness. And fairness, in this case, cuts both ways. Associated Newspapers is not on trial for being disliked, or distrusted, or aggressive. They are being challenged on specific allegations of illegal behavior. The defense strategy reflects that focus. Narrow, technical, almost clinical. That contrast, Harry's lived experience versus the defense's legal minimalism, creates friction. At one point, Harry referenced information that appeared, to him, impossibly private. Details that suggested access beyond ordinary reporting. It's a compelling assertion, but assertions invite follow-ups. How do you know it was obtained illegally? What alternative explanations exist? Could the information have come from public records? From acquaintances? From prior reporting? These questions aren't personal. They're structural, and they force a witness into a corner they may not realize they're approaching until it's too late. Because the moment you say, "I know this was illegal," you implicitly accept the burden of explaining how you know. Not suspect, not believe. No, that distinction surfaced again and again. Harry often spoke about patterns, repetition, a sense that coverage followed him too closely to be coincidental. But patterns, unless anchored to demonstrable acts, are slippery. They invite counter-narratives, coincidence, inference, alternative sourcing. The court isn't dismissing the experience. It's isolating the claim. This is exhausting work for a witness. It requires constant self-editing, constant narrowing, constant awareness that the most emotionally satisfying answer may also be the most legally damaging. And that exhaustion shows. There were moments when Harry appeared to catch himself mid-answer, to pull back, to recalibrate. That kind of self-correction is admirable and dangerous because it reveals awareness of risk. And awareness of risk invites further probing. Lawyers on both sides watch for that. The defense doesn't need to prove that nothing improper ever happened. They need to demonstrate that the claimant cannot meet the standard required to prove that something did. That's a subtle but powerful asymmetry. This is why the judge's role becomes increasingly prominent in chapters like this. Not as an antagonist, but as a filter. The court must prevent the case from drifting into a referendum on media ethics writ large. It must stay tethered to the pleadings. So when Harry's answers begin to orbit broader critiques of tabloid culture, of harassment, of long-term psychological impact, the judge intervenes. Not to silence, to redirect. Redirecting is a form of protection. For the court, for the process, and, paradoxically, for the witness. But protection can feel like suppression when you believe your story has never been fully heard. That emotional friction is now baked into the proceedings. Another complication emerges here, one that rarely gets discussed publicly. Harry's status cuts both ways. On the one hand, it amplifies scrutiny. On the other, it raises the evidentiary bar. Claims that might pass quietly in a lesser-known case attract microscopic examination here. The court is acutely aware that whatever it allows in this case sets precedent. Not formally, perhaps, but culturally. Media organizations are watching. Privacy advocates are watching. Other potential claimants are watching. That awareness creates caution. Caution slows everything down. It also exposes weak joints in an argument. For example, the question of sources. Illegal information gathering implies specific methods: phone hacking, surveillance, deception. Each method carries its own evidentiary demands. Suggesting them is not enough. Establishing them requires proof that often exists outside a witness's personal knowledge. That's not a flaw in Harry's credibility. It's a structural challenge. But structure doesn't bend for narrative convenience. As this chapter unfolded, it became increasingly clear that the court was narrowing the aperture through which Harry's claims could pass. Only certain details fit. Others, however emotionally charged, were gently but firmly excluded. This narrowing has consequences. It reduces the story's scope. It limits the emotional arc. And it forces the claimant to choose between insisting on breadth or surviving on precision. That choice is not theoretical. Every time Harry attempted to widen the frame, the court responded by tightening it. Sometimes through a question, sometimes through a pause, sometimes through silence. Silence, in court, is never empty. It invites the witness to reconsider. And reconsideration is uncomfortable when you believe the truth is on your side. This is where the audience must confront an uneasy possibility. What if the problem isn't whether Harry was wronged, but whether the law is capable of addressing the way he believes he was? That question lingers beneath every exchange. It doesn't accuse. It doesn't exonerate. It complicates. By the end of this phase, the shape of the case had subtly transformed. What began as a sweeping confrontation between a prince and the press was becoming a highly technical dispute over methods, timelines, and proof. That transformation is not neutral. It favors institutions over individuals, systems over stories, documentation over memory. And Harry knows that. You can see it in the way his answers sharpen, then hesitate. In the way he balances between saying too much and not saying enough. In the way the courtroom feels tighter with each passing hour. This is not the collapse of a case, but it is the moment where the ground hardens. And once the ground hardens, every step becomes riskier. Because the court is no longer asking, "What happened to you?" It is asking, "What can you prove?" And the difference between those two questions is where cases like this are won or quietly dismantled. But even as those questions loom, another issue is beginning to surface, one that has less to do with evidence and more to do with authority. Because when a court tightens its focus this sharply, it often precedes something else, something less technical, something far more personal. Judges don't raise their voices when they want to be heard. They don't have to. Authority, in a courtroom, is expressed through interruption, or more precisely, through the timing of interruption. When a judge chooses to step in is never accidental. It is a signal. And once you recognize that signal, you realize how much has already gone wrong before it appears. This is where the case crossed a threshold. Up until now, the court had been managing flow, guiding relevance, keeping testimony within procedural lanes. That's normal, expected, almost invisible to anyone not trained to notice it. What happened next was different, because the judge didn't just redirect. The judge pushed back, not emotionally, not dramatically, but structurally. And structural pushback is the most serious kind. The moment itself was deceptively small. A question answered, an explanation added, a clarification offered that stretched just a little too far beyond what was asked. The judge let it run, longer than necessary. That choice alone is telling. When a judge allows an answer to overextend, it's often because they want the overextension to be visible, on the record, unmistakable. Only then does the correction come. The judge leaned in slightly. Not physically, vocally. The tone changed just enough to register. Not sharper, more deliberate. A reminder was issued. Polite, firm, almost instructional. Stay within the question. Those 4 words, or their equivalent, carry more weight than most people realize. They are not a suggestion. They are a boundary. For a witness like Prince Harry, boundaries are not abstract. They are loaded. He has spent years pushing against them. Media boundaries, institutional boundaries, royal boundaries. Each time believing that the boundary itself was part of the harm. Now, the boundary belonged to the court, and courts do not negotiate boundaries. What made this moment unsettling wasn't the content of the judge's intervention. It was the necessity of it. Judges intervene when they sense risk to fairness, to clarity, to the integrity of proceedings. That means the risk was already present. From here on, the courtroom felt different. Not colder, more focused. The procedural oxygen thinned. Questions became tighter. Answers were monitored more closely. The judge began asserting control not just over what was said, but over how long it could be said. Time is a tool in court. Limiting it is a form of discipline. This wasn't about silencing Harry. It was about preventing drift. But drift, to someone who believes they are finally being heard, can feel like erasure. And that emotional mismatch matters. Harry adjusted, visibly. His answers shortened. His pauses lengthened. He appeared to be choosing words more carefully now, weighing not just meaning but consequence. That kind of self-monitoring is mentally exhausting. It fractures flow. It disrupts narrative instinct. And when narrative instinct is disrupted, frustration finds other outlets. Not anger, not outbursts. Something quieter. A tightening around the eyes. A shift in posture. A cadence that becomes more deliberate, almost defensive. Judges notice that too. Here's the part most coverage misses. A judge pushing back is not a failure of patience. It is a recalibration of authority. It signals that the court has identified a pattern it wants to correct before it escalates. The pattern here wasn't misconduct. It was overreach. Overreach in scope. Overreach in framing. Overreach in implication. The judge was not accusing Harry of exaggeration. But the structure of the intervention suggested concern that testimony was drifting into territory that could prejudice the case, either by introducing inadmissible material or by inviting interpretations the court could not control. That's when the warning came. It wasn't delivered as a threat. It wasn't framed as discipline. It was framed as guidance. But guidance from the bench carries the force of law. It was a reminder of relevance, of proportionality, and, most importantly, of consequence. Continue like this, and the court will act. The courtroom felt it immediately. Lawyers felt it first. Behind Harry, the legal team's posture changed again. This time, more noticeably. Notes were exchanged more urgently. There was less stillness. More movement. The kind that betrays recalculation under pressure. Because when a judge issues a warning, even a restrained one, it triggers a cascade of concerns. Will the judge limit testimony? Will certain lines of argument be curtailed? Will credibility be reassessed? Credibility is the quiet currency of courtrooms. It's not declared. It's inferred. And it is far easier to lose than to regain. Harry's credibility was not in question in the simplistic sense. There was no accusation of dishonesty. But credibility is also about discipline, about responsiveness, about demonstrating respect for the structure you are asking to vindicate you. That's a delicate balance for someone who believes the structure itself has failed him. Another subtle shift followed the warning. The defense began to press more confidently, not aggressively, but with greater assurance that the court would support tighter boundaries. Their questions became more precise, less exploratory. They were no longer testing. They were narrowing. Narrowing is dangerous. It reduces escape routes. For Harry, each narrowed question demanded a narrower answer. One that could no longer rely on broader context to soften its edges. This is where contradictions become more visible. Not contradictions of fact, necessarily. Contradictions of emphasis. Moments where earlier answers had leaned one way, and later answers leaned another. Not inconsistencies, but tensions. Tensions are enough. The judge didn't comment on them. Judges rarely do in real time. They store them. They let them accumulate. And then, at a moment of their choosing, they act. That's why the warning mattered so much. It wasn't about what had already happened. It was about what the court was preparing to prevent. Harry responded by trying to adapt. You could see it. He wasn't defiant. He wasn't dismissive. He was trying, genuinely, to meet the court where it was. But adaptation under scrutiny is not the same as preparation. It's reactive, and reactive behavior is easier to exploit. At one point, Harry paused longer than usual before answering. A full breath. A moment of internal calculation. Those moments read differently, depending on context. Sometimes they signal thoughtfulness. Sometimes hesitation. In this setting, after a warning, they risk being interpreted as uncertainty. Uncertainty invites probing. The judge allowed the pause. Again, a choice. Then followed up with a question that subtly reframed the issue, shifting focus from impact to method, from experience to evidence. That shift is everything. Because it moves the case further away from Harry's emotional center of gravity and deeper into technical terrain where his personal knowledge is more limited. The legal team knew this. You could tell by how closely they watched him now, how intently they leaned forward, how little they looked at the defense. Their attention was on containment. This is the moment where internal alarms start sounding. Not because disaster has struck, but because the margin for error has collapsed. Every answer must now land cleanly. No spillover, no implication, no editorializing. That's an almost impossible demand for any witness under this kind of pressure, especially one whose entire public life has been shaped by the belief that nuance and context were stripped away from his story. The irony is painful. The judge, sensing the shift, maintained control. No escalation, no visible irritation, just consistency. Consistency is how courts exert power. It's how they outlast emotion. By the time the session moved toward adjournment, the warning hung in the air. Unspoken now, but unmistakable, like a fault line exposed just enough to remind everyone it's there. Harry gathered his papers. His expression was focused, but tight. The legal team clustered more closely than before. Conversations were hushed, quick, purposeful. No one smiled. Outside, the cameras captured nothing unusual. Inside, the trajectory had changed. Because once a judge pushes back, once the bench asserts that level of control, the case enters a new phase. A phase where tolerance is measured, where deviations are remembered, where consequences are no longer hypothetical. And what made this particularly dangerous for Harry was not the warning itself, but the fact that it suggested the court was preparing for something more serious. Because judges don't warn unless they believe there may soon be a need to act. And when they act, it's rarely subtle. Warnings from the bench don't echo. They don't need to. Once they've been issued, everything that follows is shaped by them. Every question, every pause, every decision made behind the scenes. And in this case, the warning didn't close a door. It narrowed a corridor that was already uncomfortably tight. This is where the dynamic shifted from tension to consequence. Because after a judge draws a line, the next question is never whether the line will be respected. The question is what happens when someone, intentionally or not, steps too close to it. From the moment proceedings resumed, the atmosphere carried a different weight. The court was quieter, not because there was less to say, but because everyone was measuring more carefully. The judge's presence felt heavier now, not in volume, but in gravity. Authority had been asserted. And authority, once asserted, does not recede. Prince Harry returned to the witness box visibly composed, but altered. There's a particular kind of focus that emerges after restraint has been imposed, sharper, more brittle. It's the focus of someone trying to stay within bounds while still holding on to purpose. That's an almost impossible balance. His answers were shorter now, cleaner, more disciplined, but they also carried something else, a trace of tension that hadn't been there before. Not anger, not defiance, something quieter, the effort of constant self-monitoring. Self-monitoring is exhausting. And exhaustion, in a courtroom, creates openings. The judge began asking questions that were narrower than before, less explanatory, more binary, not inviting narrative, demanding clarity. These weren't hostile questions. They were efficient. And efficiency is often the sharpest tool a judge has. Each question trimmed away context. Each answer, in turn, was forced to stand alone. This is where the warning's real effect became visible. It wasn't about silencing Harry. It was about stripping away the protective layers of explanation he had relied on. Without those layers, statements become exposed, vulnerable to challenge, vulnerable to reinterpretation. The defense understood this immediately. Their posture changed. Their questions became more assertive, not aggressive, but confident. They sensed the court's appetite for precision and fed it accordingly. They didn't need to attack credibility outright. They only needed to let the structure do its work. Structure, in this setting, favors the party that says less. Harry, however, was now navigating a shrinking space. When he answered too briefly, he risked appearing evasive. When he elaborated, he risked crossing back over the line he had just been warned about. There was no comfortable middle ground. That's when the judge intervened again. This time, it wasn't just a reminder. It was firmer, still controlled, still measured, but unmistakably more direct. A clarification about relevance. A note about proportionality. A statement, calmly delivered, about the court's expectations going forward. This was the moment when the warning hardened into instruction. And instruction, from the bench, is not optional. The courtroom reacted instantly. The legal team behind Harry leaned in. Conversations during brief pauses became more urgent. The tone shifted from adjustment to tree-off. This wasn't about optimizing testimony anymore. It was about preventing damage. Because once a judge issues repeated interventions, the record begins to tell a story of its own. A story not about the allegations, but about the witness. That's the danger zone. Judges don't need to declare loss of patience for it to be understood. They simply reduce tolerance. They allow less latitude. They cut off digressions faster. They stop cushioning redirections with politeness. All of that was happening now. Harry responded with discipline. He tried. But discipline under pressure is fragile. It cracks not through rebellion, but through small missteps. An extra sentence here. A clarification offered where none was asked for. A tone that suggests frustration rather than focus. Each one small. Together, they form a pattern. This is where the phrase, stern warning, starts to carry its real meaning. Not as a headline, as a signal that the court has identified a risk trajectory and is actively intervening to stop it. Why does a judge issue a stern warning? Because they believe something is heading in a direction that could compromise the integrity of proceedings. That's not about personality. It's about preservation. And preservation sometimes requires constraint that feels uncomfortable to the person being constrained. The defense, sensing momentum, pressed tighter still. Questions were framed in ways that limited interpretive escape. Yes or no constructions. Requests for confirmation rather than explanation. The kind of questioning that turns nuance into liability. Harry navigated carefully, but careful navigation under these conditions can read as hesitance. And hesitance, once perceived, invites more pressure. It's a feedback loop. The judge allowed this to play out for a short time, then intervened again. This time, the message was unmistakable. Stay focused. Stay relevant. Or the court will impose limits. That's not a threat. It's a procedural fact. Limits can take many forms. Time restrictions, scope restrictions, exclusion of certain lines of testimony. None of them require raised voices. All of them change outcomes. Behind the scenes, the legal team faced an escalating dilemma. Continue allowing Harry to speak freely and risk further judicial intervention, or tighten control and risk alienating their own client. That's a no-win scenario. Lawyers are ethically bound not just to advocate, but to uphold the court's process. When a client's approach begins to jeopardize that balance, withdrawal becomes a consideration. Not immediately, not lightly, but seriously. Those conversations don't happen in the courtroom. They happen in hushed tones during breaks, in quick exchanges of looks, in decisions about who sits where, who speaks when, who doesn't appear at all. By now, observers familiar with courtroom dynamics were noticing absences, subtle shifts in seating, the quiet disappearance of certain advisors. Nothing officially acknowledged, nothing explained. But absence, in this context, is rarely accidental. Harry, for his part, appeared increasingly alone at the table. Not abandoned, but less buffered, less insulated. The legal scaffolding that had surrounded him earlier felt thinner now. That's when the emotional stakes sharpened. Because the warning from the judge wasn't just about testimony. It was about authority, about who controls the pace, the scope, the narrative. And that authority now rested squarely with the court. Harry has spent much of his public life challenging authority structures he believes failed him. The press, the palace, the system. Now he was inside a system asserting itself with calm, immovable force. That's a psychologically destabilizing position for anyone, especially someone who believes deeply in their cause. The court adjourned shortly after. No drama, no announcement, just procedure. But the damage, or recalibration, was already done. The warning had landed. The limits had been drawn. And the margin for error had narrowed to almost nothing. What came next would not be decided by emotion, or even by evidence alone. It would be decided by discipline. And whether Harry and his legal team could maintain that discipline under a level of judicial scrutiny that was no longer forgiving. Because once a judge issues a stern warning, the next step is never ambiguous. It is enforcement. And enforcement, in this case, was about to expose something far more serious than courtroom tension. It was about to expose fractures behind the scenes, fractures that could change everything. The warning didn't land like thunder. It landed like gravity. You only realize how strong it is when you try to move and feel resistance you didn't expect. This is the part of the story that headlines flatten into something misleadingly simple. Judge issues stern warning. It sounds dramatic, almost cinematic, as if a gavel slammed, voices rose, tempers flared. None of that happened. What happened was far more consequential. Because a stern warning from the bench is not an emotional reaction. It's a procedural decision. It is the court signaling that tolerance has been recalibrated downward, that future missteps will not be absorbed, reframed, or politely redirected. They will be acted on. And once that signal is sent, the entire courtroom ecosystem changes. From that moment forward, every word spoken is weighed against a shrinking margin. The warning itself was delivered calmly. That's what made it unsettling. There was no heat in it, no irritation, just clarity. The judge articulated expectations with the kind of precision that leaves no room for misunderstanding. Focus on what is relevant. Do not expand beyond the question. Respect the boundaries of the proceedings. Those aren't controversial instructions. They are the foundation of courtroom discipline. But when they are spoken out loud, explicitly, to a high-profile witness, it means the court believes discipline has already begun to erode. This is where the emotional undercurrent of the case becomes impossible to ignore. Because for the person on the receiving end, the warning doesn't feel neutral. It feels personal, even when it isn't meant to be. Especially when that person believes they have been repeatedly misunderstood, misrepresented, and constrained by institutions before. The warning is experienced not just as guidance, but as resistance. And resistance, when met with conviction, produces friction. After the warning, the courtroom entered a different phase. You could sense it immediately. The judge's questions became more economical. There was less patience for elaboration, fewer allowances for contextual framing. The space Harry had previously occupied, wide enough to tell a story, narrowed to something closer to a corridor. This is what judicial control looks like in practice. Not domination, not confrontation. Containment. Containment is quiet. It doesn't announce itself. It simply removes options. For the defense, this was a turning point. They adjusted their approach almost instantly. Questions that might previously have been exploratory became surgical. They weren't trying to provoke. They were trying to constrain. To keep answers boxed in where contradictions, however minor, would be easier to spot. And contradictions don't need to be dramatic to matter. They just need to exist. Harry, for his part, was now operating under a dual pressure. On one side, the judge's tightened expectations. On the other, his own internal drive to fully articulate the harm he believes was done to him. Those two forces pull in opposite directions. This is where courtroom behavior starts to diverge from public perception. To an outside audience, restraint can look like composure. To the person exercising it, restraint can feel like suffocation. Especially when you believe the truth requires explanation to be understood. But the court is not trying to understand in that way. The court is trying to decide. And decisions require boundaries. There was a moment, small, but telling, when Harry began an answer, paused, and then restarted it with a noticeably narrower framing. That kind of self-editing doesn't happen accidentally. It signals awareness. And awareness, paradoxically, can be used against you. Because once a witness demonstrates awareness of the line, crossing it later looks less accidental. Judges noticed that. So do opposing counsel. From this point on, every deviation carried amplified risk. Not because the court was hostile, but because the court had shifted from listening mode to enforcement mode. This is why the phrase stern warning matters. It marks the transition between those two modes. Before the warning, the court was willing to manage. After it, the court was prepared to act. And action doesn't always mean sanctions. Sometimes it means something subtler, but more damaging, limiting testimony, curtailing lines of argument, reducing the scope of what can be considered relevant. Each of those moves reshapes the case. This is where the legal team's predicament becomes acute. Lawyers are trained to anticipate judicial mood. They read the room constantly. And after a warning like this, the room becomes unforgiving. The safest course is restraint. Less testimony, fewer risks, tighter answers. But restraint requires client cooperation. And cooperation, under emotional pressure, is fragile. There's a psychological cost to being told, implicitly, that your story is too much. That parts of it don't belong here. That what feels essential to you is peripheral to the court. That cost doesn't always express itself immediately. Sometimes it shows up as tension, sometimes as silence, sometimes as overcorrection. Overcorrection is dangerous. A witness who suddenly becomes too cautious can appear evasive. A witness who trims too aggressively can seem inconsistent with earlier openness. The court doesn't accuse, it observes. And observation accumulates. The judge's warning also had another effect, one that rarely gets discussed publicly. It shifted responsibility. Before the warning, any drift in testimony could be attributed to the natural complexity of the case. After the warning, drift becomes defiance, even if unintentional. That's a heavy burden for any witness, especially one whose credibility is central to the claim. At this stage, the courtroom felt less like a forum for resolution and more like a test of discipline, of adaptability, of whether Harry could operate within constraints imposed by a system that does not